Would be my next question was like, does that mean that you then get your firearms taken away?
So don't know how they do it. I don't think they come in your house and like knock the door down and take them, but you're not able to buy them anymore.
Hey everyone, Nate here, Ponton's video guy. Before we jump into the video, I want to make sure that you click down below and hit that thumbs up and the subscribe button. We want to make sure we reach as many people with this information as we possibly can. And now that I've got all the fun information out of the way, this video is going to be, what do you do when you receive an incompetency proposal? I could explain it, but the fact is I don't really know what that means, which is why I've asked attorney Rachel Cheek here to explain it for us. Hey, Rachel.
Hey.
Yeah, could you explain what an incompetency proposal is?
Absolutely.
Yeah.
So let's start with what incompetency is.
Okay.
And when we say incompetency, this is only for VA purposes. It means different things in different jurisdictions. I'm not talking about guardianship. I'm not talking about what the state says is incompetent. I'm only talking about VA incompetency. So with that disclaimer, when VA says someone's incompetent, they mean they're incompetent to handle their own finances, which includes VA benefits. This is a protective thing that VA does. The idea of it is you don't want someone who, has severe dementia and doesn't really know like the impact if they were to give their whole check away to, someone one day when they get paid, or a veteran with, manic episodes who doesn't have anyone to watch out for him, who will go gamble his check and more away, the first of the month. So it's intended to protect veterans because, if you're getting VA disability, you need it. Mm-hmm. And the truth is at some points, that disability can impair you from managing your own finances. So when VA finds someone incompetent, again, unable to manage finances, they will propose incompetency. And we'll talk about the steps for that. Mm-hmm. But skipping ahead to what happens if VA finds incompetency, that means the veteran is no longer the immediate recipient of their monthly benefits. VA will name a fiduciary, and that can either be someone that you know. Oftentimes it's a spouse. If you're married and your partner is competent, they will just assign a spouse, which means that your monthly benefits will just go in their account or a shared account, whatever. The spouse has to be, the named person has to be in control of it. If you don't have a spouse or a family member or friend or someone that you want to name, VA will name a fiduciary. They have people who that's their sole job is to be responsible for the intake and disbursement of veterans' benefits. Obviously, that's not something that we love to have happen because if it's your spouse, it's one thing. We can trust that the spouse is going to, we hope that the spouse is going to do the best thing for the veteran.
Yeah.
Now, of course, a fiduciary appointed by the VA does have to they have to meet certain standards. They're not just going to give it to someone random.
But it's someone random who goes through hopefully rigorous, I guess, questioning or testing?
I don't know how rigorous, but yes, they have to meet some qualifications. Okay. And they're recognized by VA as a fiduciary, which again, in certain circumstances, that's the best thing. You don't want a veteran to be out on the street because they didn't pay their rent because they just weren't aware that they had money coming in. So I see what VA is trying to do with it. However, sometimes they can be a little overzealous in proposing incompetency. So I want to tell people what to do in case that happens.
So you get this letter in the mail that is an incompetency proposal. Why are you getting that?
So most often, and there may be, I'm sure there's different circumstances, but most commonly what I see is a veteran has just had a CMP examination for mental health or PTSD or TBI, or he has just had an aid attendance examination. And the reason I know it's those examinations is because in the CMP questionnaire, one of the questions for the mental health and aid attendance is Is this veteran able to manage their own finances? Sometimes I think a lot of times a vet will sit down, you're in an exam and you're just answering questions. Do you handle your own finances? Like, no, my wife does it. My wife pays the bills. That, I think a lot of times examiners will hear that and say, nope, doesn't handle her own finances. Wife pays the bills. But then you talk to the veteran and they're like, well, yeah, she handles the bills. But I know my monthly benefits that are coming in. We make purchases together. I'm not unaware of what happens financially in the household. So again, most often it's going to come from that. And the thing that makes a lot of my clients worried whenever they hear anything about incompetency. So not only will your monthly payments not be going to you, but this can also trigger you to be ineligible to own firearms. Which, as you can imagine, for a lot of veterans, that's something they're used to. That's something that gives security. That's important.
It's gonna be my next question. Was like, does that mean that you then get your firearms taken away?
So I, don't know how they do it. I don't think they come in your house and like knock the door down and take them, but you're not able to buy them anymore. And technically are not allowed to own them like on it's a federal law because VA's, federal program. So again, understandably that's the thing that worries a lot of my veterans who get incompetency proposals. So, but I do want to say, just because it's a proposal does not mean it's going to be completed. The vast majority of cases that incompetency is proposed, it's never taken. I won't say it's easy to fight, but it's simple if you know kind of the formula. So you get an incompetency proposal.
Okay.
Again, probably triggered from a CMP examination. What do? Well, first you want to immediately request a hearing. You have, I believe, 30 days after an incompetency proposal is issued to request a hearing. And request technically an incompetency hearing at any time, but if it's after the first 30 days, it's at VA's discretion, meaning they don't have to give you a hearing. But if you do it within the first 30 days, they have to. And when request is made, VA can't make any decision until that hearing is done. So that immediately kind of stops your clock if you request a hearing. And hearing means essentially like a video conference or a telephone call with a decision review officer. We often don't even get to that point. So, but you want to request the hearing because you don't want VA to move on and find you incompetent.
That's the first 30 days. And now you said you have 60 days. And that's you have up to 60 days to send a letter, or after 60 days from when you receive the incompetency proposal, then you can send in?
Thank you for clarifying.
Yeah.
So it's actually the 60 days following getting that letter, you have to submit new evidence. And usually what we'll do is a statement of the veteran and a statement of their spouse. That's generally what happens because at the examination they've said, well, no, I don't handle it, my spouse does. So you want statement to show that you're both aware of the amount of money coming in, your VA payment, any retirement benefits. You also want to note that you don't make large purchases without each other. Again, remember, incompetency is to protect veterans so that they have their, the amount of benefits they should have. So it's not as though they're going out and buying new cars without talking to the spouse. Similar with the spouse, they can note that I handle the actual paying of the bills, but we discuss any big purchases. And, I believe my spouse is competent to manage the finances. I trust that they would manage it if they needed to. And a letter from the veteran's provider, preferably a mental health provider, noting that, this is my patient. I've been their doctor for X amount of years. I have no reason to believe this patient is incompetent. I think they're fully capable to manage their own finances. Generally, those three pieces of evidence, all you need is to submit those. Again, you are requesting the hearing, but you don't have to actually have the hearing. If you're able to get your evidence together in those 60 days and submit it, oftentimes what we'll do is just waive the hearing request altogether. So, yeah, we filed it, we know, but forget that and just check out the evidence. Make a decision, please. So that way you're not, you've gotten this evidence together and you're not like waiting on the VA to schedule a hearing, which can take a really long time.
Mm-hmm.
But again, it's like a protective measure to request it ahead of time.
So if you submit all this, but the VA still finds you incompetent, do you appeal that? Like, how does that work?
Yes, you can. Again, sometimes it's correct. I've a few clients, I can think of maybe 2 off the top of my head, out of like 400 that were, I don't want to fight it. Just name my spouse the fiduciary, which is, I get.
Yeah.
You don't have to worry about it. Don't worry about it. But you can appeal just like any other VA decision.
Okay.
Usually what I do, if you've already submitted all that evidence, just file a higher level review appeal and let VA know, hey, I don't think I should be found incompetent. Here's the supporting evidence as to why not. They could reverse it. If they correctly find it, as I said, they will name someone to be a fiduciary, most often the spouse.
And this is something that you've worked with before?
Yes, we do have this happen. Incompetency proposals, again, I would say 95% of them are never taken. The ones that are taken is because the veterans didn't want to fight it. I say the great majority of the time, all VA needs is actual evidence from the veteran, their own provider, their spouse, family members even. Because you take that information and then you compare that against why they propose incompetency, which is a CMP exam from someone who doesn't know the vet beforehand, may have spent 15 minutes with them, may not have even looked at their file. Usually the actual evidence that you submit contesting the proposal is going to outweigh whatever caused the VA to propose it in the first place.
Interesting. So that's good. If you get an incompetency proposal, it's not something to be scared of.
Exactly.
Gotcha.
It's something to be proactive about, but it's not the end of the world. Proposal is not a finding. It is as simple as something in the VA can be to contest.
Gotcha. So quick recap, you get the incompetency proposal in the mail, you have 30 days to request a hearing, and then you have 60 days to submit evidence to kind of say, hey, here's why I'm not going to be found incompetent. And then if that evidence is successful and it's overturned, you don't have to worry about going through with the hearing. You can waive that, or you might have to go through with the hearing. And then if everything you submit gets denied, you can still appeal that, and your recommendation would be a higher level review if you've already submitted evidence for that.
Yes, and if you hadn't submitted evidence, I've fallen behind on stuff myself, but you would just file a supplemental appeal probably with that evidence that we talked about.
Thank you so much for watching. If you have any more questions, you can click the link in the description below, and it's an article that talks about incompetency proposals. And as always, thank you for watching, and thank you for your service.